And welcome back. Now, government says that the Land Expropriation Bill has been certified as constitutional by the Chief State Law Advisor, which paves, of course, the way for it to be gazetted and sent to Parliament for consideration. The bill was drafted in consultation with around 50,000 comments from South Africans, along with business, labour and community stakeholders. So let's discuss this further with Public Works and Infrastructure Minister Patricia De Lille. Minister, good morning. Thanks for being with us here on Morning Live.
Good morning, Sakina.
Let's just start by looking at the 50,000 plus comments that were sent by South Africans. How did you actually deal with that?
Sakina, if you may recall that the first version of the bill came before Parliament in 2018. And the 50,000 comments that we received, it took us about 6 months to consider all of those comments. Some of the comments were worked into the bill. We consulted sufficiently with a very good legal team. And we have also consulted with business, government and communities at NETLEC. So we've gone through a thorough consultation process. Where we are now is that the bill must now be subjected to the parliamentary processes. That's why I have submitted it to the Speaker and the Chair of the NCOP on Friday. And we must also respect that process.
So just coming back to some of the comments that we've heard from people who said that their considerations were not entertained at all. How do you respond to them if they're watching right now, Minister?
Sakina, this bill is to replace a 1975 Act of Expropriation that is inconsistent with the Constitution. And therefore, we had to also consider the new constitutional values, the preamble of the Constitution, that we need to build a united South Africa, united into our diversity. And we have tried our best to listen to as many comments as possible. But this is not the end. Every South African still has got an opportunity again to make submissions to Parliament once Parliament announced how they will process the bill. Expropriation is nothing new. It has been done and is being done all over the world, in the United States, the UK. Some countries just call it by a different name. But also a lot of the comments was around the proposal of no compensation. But no compensation is not prescribed in the bill that it must be done. It says in the Constitution that we must pay just and equitable compensation. And also, if there's no agreement between a government and a landowner, the courts will be the final arbiter. As we speak now, Sakina, the president, 7 premiers of our country, all our municipalities, they all have rights to expropriate. What was needed was a law of general application so that we can ensure that the procedures are in line with the Constitution.
And you say to this end, of course, the necessary checks and balances have been done so that this will pass constitutional muster, Minister?
Yes, definitely. The Chief State Law Advisor has certified the bill as being constitutional. It will now go to Parliament. Parliament will further look and see if they agree with that. So we have tried and cross all the dots and the T's, Sakina, so that Parliament can proceed with a process that's open and transparent. But also, this is expropriation is part of government's overall program of land reform that include land restitution, land redistribution, and land tenure. And as we all know, that there's a backlog of dealing with land reform issues. And this is an attempt to, as soon as possible, begin to use all the mechanism at our disposal to do land reform. expropriation is not the silver bullet. It is just but one method. It is an acquisition method where if, for instance, the state needs a property or land for the purposes of the public good, if you want to build a power station or you want to build a dam, and that is for the public interest, then expropriation will be considered. But before that, there will be interaction with the owners. And the bill prescribes now when you can expropriate and how you can expropriate. A general law of application that was missing. And this 1975 Act is way out of tune with our current constitution.
Minister, you say the bill actually then describes when and why, but does it actually say how and how you would go about actually identifying land to be expropriated?
Well, in terms of the House, Sakina, the three spheres of government, national government, provincial government, or even local government, they can determine the need where they need to bring in more services, improve service delivery, create opportunities. That decision will be taken there. Then all three spheres of government must then follow the same general law of application to expropriate. But it is a process that is not one-sided. In the process, it's being designed to give the property owner the right to engage with government. As you can see now, government came with another policy in terms of land reform and asking people to donate land to government. So you might not always expropriate because there are also many people who want to make donations to government.
So just on further clarity, Minister, Section 25
Yes.
of the Constitution says that no one may be deprived of property except in terms of law of a general application, and no law may permit arbitrary deprivation of property. Now, during yesterday's press briefing, you made mention that government will determine if land is not being used and will then make means of expropriating that land for development purposes. But again, this gets people all jittery if for one or another reason they are perhaps incapable of working the land that they own at this time. So can you just give us a further clarity and explanation around this?
Well, Sakina, it depends on the nature of the property. For instance, if the property is a health and safety risk and it poses a risk to communities, and it's not being used for any purpose, that is one of the considerations that government will give. The second one, too, is that government need that land for for public purposes, for public interest, again, for service delivery. That will be considered. You know, this is not a bill that's one size fits all, and that government is just going to expropriate left, right, and center. That's why we are underlying the conditions under which government, that include national, provincial, and local government, may consider when they need that piece of land for that purpose. But Sakina, in terms of our own history, also of the spatial injustices, in terms of the need for land in our country, this land reform program and the recommendations that we are implementing now. In 2019, in June, an inclusive advisory panel to the president made many recommendations, and more than 75% of those recommendations were accepted by government. And even the advisory panel at that stage did a lot of public consultation. So the emphasis here is not just on expropriation, but to use land redistribution, land tenure, land restitution, all as methods, as a way to drive land reform in our country.
And then just reading some of the comments, especially also after yesterday's briefing, there does seem to be some confusion, and some even saying that there seems to be a contradiction with regard to land expropriation, because the bill, which was gazetted on Friday, actually brings much more certainty about exactly how expropriation can be done. But then there's the question that this does not replace that separate parliamentary process, considering Section 25 of the Constitution and, of course, expropriation without compensation. So can you just give clarity to our viewers in that regard, Minister?
Yes, Sakina, there are two processes. The one process that we've announced yesterday as the Interministerial Committee is the replacement of the 1975 Expropriation Act. And the Chief State Law Advisor has confirmed that the bill is consistent with the Section 25 in the Constitution as it stands now. There's another process happening whereby Parliament has established a multi-party committee to look at the amendment of Section 25. Now, Parliament is separate. Parliament is there to make the laws, and Parliament can also amend the Constitution. So that it's separate because we have made sure that this bill is consistent with the Constitution as it is right now. So Parliament has control over their own processes. Parliament will decide whether, in view of the fact that the bill now makes provision what is implicit in the Constitution, whether Parliament proceed. But it's not for the executive authority to prescribe to Parliament. So yes, there are two processes taking place at the same time.
So in the event that the land that is earmarked for expropriation or is expropriated and that land is still held in a bond, Minister, who's going to settle the bank with regard to that particular land?
Sakina, I've looked at whether we have got in our new dispensation since 1994 any court cases whereby the courts were involved. And just starting with our apex court, the Constitutional Court, in the past 20 years, not a single case on expropriation was decided on by the courts. And the courts will also be involved now in assisting in the event that there is a dispute. But the Constitution doesn't speak about willing buyer, willing seller. Sometimes it is just there to malign Section 25. Market value is one of 5 considerations that the government must consider when you expropriate. So I think we are in exciting times where we are able to bring about legal precedents in future, how we can deal with it. We respect the separation of powers between the judiciary, executive, and Parliament. And because our courts has hardly dealt with expropriation over the past 20 years, our courts will now also become involved to assist us to get the correct interpretation of our Constitution.
Well, Minister, just before I let you go, just a quick one with regard to the Beitbridge border fence debacle. Parliament's finance watchdog Scopa is calling for a further probe into your involvement in this matter. And they also want to know more about your advisor, Melissa Whitehead's involvement in this project. Yeah. Can you give us clarity on that 40 million rand controversy?
Well, first of all, Sakina, I respect the role of Parliament. I want to be held accountable. The more I'm held to account, the harder I will work to act against corruption, like I've done in the case of Beitbridge. I, on the 20th of April, wrote to the Auditor General, asked for an investigation. On the 25th of April, I stopped any further payments to the contractor, including instructing our anti-corruption unit within the department to investigate. And if there are any further investigations, I've always cooperated and will cooperate with any further investigations. I've never said I don't want to be investigated. So I've got no problem with the decision by Scopa if they want this matter to be further investigated.
Well, Minister, we have to leave it there. Thank you so much. Minister Patricia De Lille is the Minister of Public Works and talking to us about the Land Expropriation Bill, which has been certified as constitutional by the Chief State Law Advisor and has been gazetted and sent to Parliament for consideration, among other issues. Let's take a quick break before we bring you the news at 7.